Hi, this is Attorney Clay Dawson of the Dawson Law Firm. This video is on jury instructions. That does not sound interesting. Jury instructions. And you know what? I see attorneys ignore jury instructions. And if you're not an attorney, you probably won't benefit a whole lot from this video. It may give some insight on ways that things should be approached. Jury instructions are very useful from before you ever file suit. Each state has pattern jury instructions. In North Carolina, we have pattern jury instructions for civil cases, for criminal cases, for motor vehicle cases. And they are meant for a judge at the end of all the evidence to read to the jury and to tell them what the law is. Isn't that great? We have the jury listen to all this evidence and they don't even know what the law is. And they don't have the benefit of knowing what the law is when they're hearing all the evidence, but that's the way it is. And the jurors do the best that they can. And the judge does the best he can to instruct them, to tell them what the law is. And that's what jury instructions are intended to do. I see too many attorneys in a jury trial. At the end of all the evidence, the judge has a conference with the attorneys and asks the attorneys whether they have any recommended jury instructions. And too often they just say, well, no. And the judge will usually tell them, these are the jury instructions that I'm going to give. And usually a good, experienced judge knows the instructions he or she has to give. Most of them are just standard burden of proof, testimony witnesses, and so forth. But attorneys should already have recommendations for their jury instructions. For instance, you can ask a judge to insert into a jury instruction things that you want the jury to consider. You could have the judge insert in a jury instruction your contentions. And that would go something like this. Well, the plaintiff contends that he was operating a motor vehicle at a speed of 35 miles per hour, and on and on and on, just so that the jury gets a quick summary of what your contentions are. This is really good for things like pain and suffering and for damages. If the judge can give your contentions, it helps the jury focus on that. So I think that everyone would agree that jury instructions can be very helpful before the jury deliberates. But they can be very helpful before you ever file suit. How can that be? Jury instructions can be used as legal research. Obviously, jury instructions, if they can tell the jury what each and every element of an issue is, whether it's negligence or contributory negligence or last clear chance, or whether it's the definition of larceny, etc. If these jury instructions can tell a jury that, they certainly can tell an attorney what the elements are that he has to allege, what he has to plead, and what he has to prove. And it can help an attorney with his pleadings. I think that it really helps an attorney to have his pleadings mirror the jury instructions. Because that way, at the point where the other side makes motions challenging your case, you can point to the jury instructions and say, well, Your Honor, the law is such and such. And you know what? The jury instructions are footnoted and tell you the law that supports them. But it gives you the case law, and when you read a jury instruction to a judge on something, he's going to take that. He knows that's the law. So if you have a pleading, a complaint, or a counterclaim, that sort of thing, where you have made allegations of claims. If those are challenged, you can note what your evidence is, what your pleadings are, and what you have to prove. And what you have to prove is specifically outlined in the jury instructions. Here's another reason that attorneys need to be aware of jury instructions. Occasionally they're wrong. In North Carolina, the larceny jury instruction is wrong. I recently had a felony larceny case, and the state was very comfortable prosecuting it. And I'm afraid they probably prosecuted other people and got convictions against them, having a very faulty jury instruction read to the jury. In larceny cases, for instance, a key element of larceny, which you learn in first year of law school, a key element of larceny is a trespassory taking. It has to be a trespassory taking. If I give you my wallet and you don't give it back, that's not larceny. That wasn't a trespassory taking. It's that trespassory taking that makes it, it gives them an element which makes it different from other crimes. So I had a DA that's perfectly comfortable prosecuting. Actually, 2 DAs have been involved in that case. They were both very comfortable with it. I told them, I said, this is not a strong case for the state. I didn't tell them why, because I don't want them making the case fit whatever, or making charges fit whatever the case was. But they were very comfortable with it. Had I allowed the case to go to the jury with that jury instruction, my guy might have got convicted. Fortunately, I'd already read the jury instruction and knew that it was wrong, so I researched the issue and pulled up 2 very good cases on larceny and trespassory taking, and at the end of the state's evidence, I made a motion to dismiss based on the fact that there was no evidence of a trespassory taking. And my case has established that. The state's case was dismissed. Judge gave the state an extra day to do legal research to find anything that would support their version of the case. They couldn't do it. It was dismissed. So the jury instructions need to be looked at to be made to ensure that they are correct, because they will be read to the jury unless you have vetted those instructions. If there's something wrong with an instruction, you need to let the judge know. This is Attorney Clay Dawson of the Dawson Law Firm. Thank you for watching.